KTV4, the Community Television Network.
The Frank M. Coffin Lecture on Law and Public Service honors the distinguished career of Judge Coffin and brings to the University of Maine Law School and to the community leaders who have made significant contributions in law and public service. On today's program, the Honorable Patricia M. Wald, Judge of the United States Court of Appeals for the District of Columbia Circuit, offers advice and admonitions for altruistic young lawyers.
In the concluding section of On Appeal, Judge Coffin eloquently argues for what he calls a community interest in our troubled and divided society, a theme most appropriate to the law and public service topic. I quote Judge Coffin, "Such an interest suggests not only a safety net to stave off catastrophe for the most unfortunate, but ways and means to enable the grievously displaced and disadvantaged to make re-entry into the mainstream of society. Reintegration, participation, mobility, and access are the ultimate goals if we are not to surrender to the prospects of a class-crystallized, elitist, anti-democratic, and dangerously divided society." It is now my great pleasure to introduce the author of those words, the Honorable Frank M. Coffin. Judge.
Now a word about Judge Wald's court and cases. The Court of Appeals for the District of Columbia Circuit is a hybrid. First, it has the jurisdiction and business of any of the regional courts of appeal like my own First Circuit, but it is also charged with a highly specialized mission. Ever since and even before the days of the New Deal, the country has relied more and more on administrative agencies to carry on its business. And the principal court of our administrative state is the D.C. Circuit Court of Appeals. What this means is that its judges must tackle cases where the administrative records fill boxcars. They must understand and assess not only statutes but regulations, rulings, and interpretations. And in so doing, they must preserve a delicate balance between agency autonomy and the rule of law, and maintain in working order a good part of the engine of national government. Judge Wald's opinions reflect this rich diet of complexity and diversity, ranging from the regulation of sulfur dioxide fumes, oil pipeline pricing, and mining safety laws, to nuclear plant evacuation plans and urinalysis testing for executive branch employees. The judge sits on a court in an area where there are no United States senators. This means that its judges reflect the swings of the pendulum of presidential politics, and a president can find his nominee in any part of the country. Despite this, Judge Wald has shown that she can work harmoniously with judges of a different ideological persuasion. Nowhere was this more apparent than in the case of Armstrong versus Bush, in which, writing for herself and two Republican appointees, she upheld an injunction preventing the administration from erasing from National Security Council computers the last 2 weeks' traffic in the Reagan era. But her dissents are also memorable, ranging from standing up for unpopular activities, such as demonstrating on the White House sidewalk and a Ku Klux Klan march from the Washington Monument to Capitol Hill, to an unheeded call that Oliver North's conviction should stand, that he did indeed receive a fair trial in all respects. It is my privilege and honor to present the Honorable Patricia M. Wald.
Thank you, and thank you, Dean, and thank you, Judge. It's a great privilege for me to be here in Maine, a state that I dearly love and have enjoyed as a tourist previously, but especially to be here for the Frank Coffin Lecture. Frank Coffin is my ideal of a public servant. As a judge, as an administrator, as a congressman, he epitomizes for me what Ernest Hemingway once called courage, defined as grace under pressure. I'm sure that Judge Coffin never suffered any of the dilemmas of public interest lawyers that I'm going to talk about tonight. But for some of us lesser beings, and for some of you out there that may be thinking about a career in the public interest, I hope he'll be indulgent. Make sure this is okay. It is by now a ritual for judges and elders of the bar to lecture prospective young lawyers that they should devote a significant part of their career to pro bono work. Pro bono, of course, is short for pro bono publico, for the good of the public. And I can certainly attest from my own 40 years in the law that there are great satisfactions in devoting one's skills to a cause larger than money or even professional reputation. But I can also tell you that doing good can be hard work, and that a lifetime of public service requires just as much, probably more, prudence, discretion, judgment, tolerance for frustration, and long-range perspective as profit lawyering. Tonight, drawing on my own experiences in 3 phases of public interest lawyering, I'll discuss some of those conflicts and dilemmas that non-traditional lawyering poses. I do this, heaven knows, not to discourage any would-be novitiates, but to counsel a kind of idealistic realism, to be contrasted with unfocused feel-good notions about donating one's working life to the great unwashed, certainly the great undefined public interest out there. Now, the Bible warns against squandering one's talents profligately, and there are just so many years, just so much energy and commitment in any lawyer's lifetime. A series of tough questions, not all of which I can answer myself, may help steer those of you interested in public service careers closer to success, which I define as a sense at the end of your career that you have contributed, commensurate with your talent and skills, to the slow but measured advance of your community and nation toward a more just society. So my first question would be, why do I want to serve the public interest anyway? Reserving for a moment the definition of what that public interest is. In short, what's the source of my altruism? Is it really concern for others, or a thin disguise for less laudable motives? A good resume, useful for those with political or even judicial ambitions, or an opportunity to feel good about myself and superior, even controlling toward those I serve without pay? A welcome contrast to the irritating demands of a paying client. A reviewer of Robert Cole's recent book on altruism commented perceptibly, "Among the many forms of human action, few are subject to more misunderstanding, cynicism, or rancor than the idealistic ventures of volunteers and activists who try to make life better for someone else." And in much the same vein, Anna Freud once observed, "How sad that in the name of goodness and kindness to others, one can see plenty of mean-spirited behavior, a demanding, controlling, manipulative, condescending, self-centered ruthlessness that masks itself as goodwill, as an effort at charity, as an attempt to change the world, reform a given society." Now, some say, consequently, the only true altruists are those who perform small, anonymous acts of charity in their daily lives, not global reformers. But that kind of selflessness is hard to sustain. Early in my own career, I did legal services work, and I enjoyed it. But after a few years of running to court to stay evictions, seeking child support for bereft mothers, trying to recoup denied welfare benefits, I became a class action test case junkie. desperately anxious for the single mandate that would spell meaningful relief for the many. But for those dedicated young lawyers who do invest many more years, affording poor people, children, aliens, criminal defendants, individualized legal help, they deserve our applause. But many, like myself, eventually gravitate toward a kind of public interest work that aims at more dramatic changes in laws. The so-called public interest segment of the bar, which was spawned in the 1970s and now claims over 1,000 lawyers in 160 public interest centers throughout the country, financed primarily by individual contributions or foundation grants. After decades, a few decades of pro bono practice, no one yet has a sharp or a clean definition of public interest law. Years ago, Thurgood Marshall enthused about lawyers who, quote, provide representation to a broad range of relatively powerless minorities, to the mentally ill, to children, to the poor of all races. They represent neglected interests that are widely shared by most of us as consumers, workers, and individuals in need of privacy and a healthy environment. He said these lawyers have made an important contribution. They've made our legal process work better. And by helping open doors to our legal system, they have moved us a little closer to the ideal of equal justice for all. Another early public interest lawyer described it this way: we were doing what the elite law firms were doing for corporate clients, except we were doing it for citizens organizations, for poor people, civil rights groups, neighborhood development corporations, consumers, and environmental groups. Now, that kind of client-oriented definition of public interest law didn't last long, however. The young conservatives of the 1980s claimed the same mantle of public interest law for themselves as well. Generously supported by corporations, trade associations, and some foundations, these new recruits didn't see their mission as representing the previously unrepresented. To the contrary, they advocated the case of private developers against land use regulators, opposed limitations on the use of pesticides, fought standards for automobile emissions, but with their arrival on the scene, public interest law could no longer be viewed as a monolithic movement dedicated to a single political agenda. This capsulized history raises a second, related question for young lawyers embarked on a public interest career in the private sector. How do I define the public interest I so unselfishly want to serve? You can, of course, throw your lot in with a defined constituency group, acting as the legal arm of a larger political or social movement. Sierra Club, the Legal Defense and Education Fund of the NAACP, the Native American Rights Fund, the Women's Law Center, and so on. Lawyering for such groups in some ways doesn't differ that much from private practice. The lawyer is obligated within professional and ethical rules zealously to advocate his client's causes as defined by those clients. And although young lawyers representing such groups may get more frequent chances to participate in policymaking of their organizations or to exercise more control over what cases are brought because of shortages of funds, still they must decide if the organization's overall goals and priorities are their own. Thus, across the legal landscape, we see environmentalists opposing Native Americans, labor unionists vying with racial and ethnic minorities, and women's advocates, pro-choicers pitted against right-to-lifers, all perceiving themselves as public interest lawyers. In reality, of course, they represent only one of many segments, and that's the reason why their critics so often refer to them, not totally illogically, as special interest lawyers. Often their claim to the public interest label lies principally in the notion that by representing the unrepresented, when that's true, they legitimize and fortify the basic adversary legal system for settling disputes. Now, this fact of life dictates a considerable degree of humility about one's status as a public interest lawyer, and it also dictates care in the selection of causes. Few public interest lawsuits are zero-sum games. As in all litigation, someone wins and someone loses. But in utilizing the resources of the law to promote the interests of one part of society over another, Public interest advocates, or special interest advocates, if you will, are playing with heavy weapons. They are forcing society's hand on some of the most difficult resource allocation choices it has, weighing in on one side of the scale against other sides. According to Jack Greenberg, who was the former director of the Legal Defense Fund, you have to strike a balance and with each case judge whether the net effect will be better than if the case had not been brought. It's always a judgment call. What's not totally clear from Jack Greenberg's statement is whether the net effect is calculated according to the client group's interests or the effect on society as a whole. And that, of course, is the conscience always prodding public interest lawyers. Is it enough if I ask whether the case advances my group's special interest, or should I include the harder question of whether society's interests are furthered? Now, in the real world, as practitioners like to call it, young lawyers must initially make a decision that their comfort level is high enough with a special group's agenda that they won't need to recalculate the net win-loss ratio on every case. But there will often come a point in every cause's career when a lawsuit looks so skewed or even antisocial that she will balk, and if it happens frequently enough, feel compelled to leave. That's the framework within which all conscientious special and public interest lawyers live. And I think it's a markedly different one from the archetypical tobacco lawyer who was asked, as Roger Rosenblatt did recently in the New York Times, how he can live with himself, or even the non-discriminating counsel who doesn't attempt to make any judgments at all about whether he's doing good or bad for society. Let the courts decide, he says. So why the higher standard for non-commercial lawyers? For one thing, they play for higher stakes, usually not content to reallocate resources from one individual to another, but rather trying to make government or major economic forces behave in a particular way, shifting resources to benefit one segment of society, usually at risk of another segment. And although it's true only as a generalization and blurry at the edges, this responsibility entails harder ethical choices. On a more personal basis, most lawyers who eschew straight private practice do so at substantial monetary cost, and their personal self-worth requires they do a periodic self-audit to determine whether the trade-off continues to be worthwhile. Dixon v. Weinberger was a deinstitutionalization case also brought in the 70s that sought to accelerate the release from long-term institutions of mentally ill persons who could make it on the outside if they had adequate support. The cruelty of being kept for an entire lifetime in barren, sometimes brutal settings without treatment or rehabilitation seemed clear from the start. What became clear only later, however, was that society was not yet willing to provide the resources to allow those inmates to survive outside the institution. The residential facilities, the job training, the outpatient care, the crisis intervention services they needed. Without those resources, is life on the streets better or worse than inside the institutions? We are told that an estimated 1/4 to 1/3 of homeless people in the nation suffer from mental or emotional illness. Now, one of the first cases that the Mental Health Law Project, in which I worked in the 70s, brought all the way up to the Supreme Court was that of Kenneth Donaldson, a Florida mental asylum inmate who'd been locked up without treatment for 15 years because of chronic schizophrenia, but he was not considered dangerous to himself or others. Our lawyers argued that such a person could not be institutionalized against his will without treatment, and the Supreme Court eventually agreed that he ought to be released. Actually, in the 20 years since, he's become a self-sufficient member of society as well as a reformer of the mental health system. Testifying before Congress a few years after his release, Donaldson spoke about his 15-year ordeal in an underfunded, understaffed Florida institution. He said, "The saddest thing is seeing people die in front of your eyes. Not only old men, of course go quicker than young ones, they would give up hope after about 2 years. People deteriorate physically when they're in confinement, even young people, but many of the older people just give up." For 10 years, Donaldson's only doctor had been an obstetrician who cared for 1,300 other patients, appearing once every few months to ask the same few rote questions. What ward are you on? Are you working? Are you taking medication? During this time, Donaldson witnessed sadistic attendance, physical abuse, free intermingling of insane criminals, and docile, senile old men. Donaldson remained convinced he survived only because he refused to take the medication. But the deinstitutionalized suits were not confined to the Donaldsons who could likely survive on the outside without special services. Our plea was for those who didn't need to be institutionalized if they had the support of outside services. And our requested relief was that the community simultaneously reduce institutional population and establish alternative outpatient services. In Washington, we sued both the federal and the D.C. governments who had overlapping responsibilities for St. Elizabeth's, which was our mental institution. We asked for patient evaluations, discharge of those who could be maintained on the outside, prompt establishment of needed community services, and judicial monitoring of a plan to accomplish the transfer. Ambitious? A bit, I would say in retrospect. But our legal theory was that patients whose liberty is taken from them through civil commitment have a right to the least restrictive kind of control, and in this case, outside living, with the requirement they accept monitoring, psychiatric services, specialized living conditions, whatever it took to keep them from posing a danger to themselves. The hospital staff itself calculated that 43% of the inmates, roughly 1,000 patients, didn't need total institutionalized care. Again, as in Mills, we had a statutory ground for our suit. The 1964 Hospitalization for the Mentally Ill Act required the district to place patients in the least restrictive alternative settings necessary for their or others' care and protection. But our lead plaintiff, in this case, Herbert Dixon, was a very different type of patient from Kenneth Donaldson. He was confined to a wheelchair, 65 years old, institutionalized for 23 years, often confused and disoriented. Our mental health experts told us Dixon and others like him, needed small community-based homes with adequately trained operators and visiting therapists. We estimated 350 such personal care homes serving 6 patients apiece would be needed in the district to take care of those who met appropriate outplacement criteria. Medicare, Medicaid, and SSI, Social Security entitlements, could provide some of the funds for community care, but clearly not all. The suit was filed in February 1974. In December 1975, District Judge Aubrey Robinson ruled that the D.C. and federal governments must jointly create community-based services for patients who could live outside of a total care situation. It was not, however, until April 1980, after 5 years of negotiation, that federal and city officials finally agreed to a plan outlining the standards for assessing patients eligible for outplacement and the community facilities into which they could appropriately be moved. The court approved that plan, and it set up something called the Dixon Implementation Monitoring Committee as the enforcer. In October 1984, that's 4 years after that, Congress set a schedule for transfer of the operation of St. E's to the district, and again mandated a comprehensive community-based mental health service system. In March 1987, 3 years later, the D.C. Commissioner of Mental Health agreed to a specific timetable for the creation of community residences and outreach services. In June 1989, 2 years later, the district signed onto a new 2-year schedule to reduce hospital beds at St. E's and develop alternative community living arrangements. In January 1992, the court ratified a new consent order between the lawyers of the Mental Health Law Project and the district for a 5-year plan to accommodate 5,000 patients, including 2,500 homeless in 375 residences at a cost of $8 million. In May 1993, the same judge, frustrated by the failure to make any serious starts at implementation, appointed a master to oversee its development, lamenting, 12 years is long enough for the district to perfect and effectuate a system which protects the legal rights and lives of the mentally ill in the community consistent with the statutory mandate. Now, I introduce a personal note here that gives some perspective on the pace of these developments. Between 1975 and 1994, I was appointed to the Court of Appeals. After 7 years, I became the chief judge. I served 5 years of my term, continued as an active judge in the 4 years since that time. Judge Robinson, who was the trial judge in the Dixon case, became chief judge of the district court. He served his term of 10 years and took senior status. All of this period, we were working together. After 20 years, the case still drags on. Now, 3 months after the master was appointed, the D.C. Council repealed the 30-year-old statutory provision guaranteeing treatment in the least restrictive setting on which the lawsuit had been based. In April '94, the master, whose one-year term was scheduled to end last July, again reported botched contracts, untrained workers, budget problems, and an overall lack of commitment from the district. So St. Elizabeth's is a sad and unfinished story. Other cities, small and big, have variations on the same theme. In January '94, PBS, Public Broadcasting, ran a frontline story called A Place for Madness, detailing the results of a similar deinstitutionalization suit in Massachusetts. In 1955, 2,300 mentally ill people were living in wretched conditions in a state hospital in Northampton. A class action brought on a theory similar to ours obtained their release. Now the institution has been closed down. Only 25 remain in a total care setting. The town complains they're roaming the streets, although actually few disruptive incidents are reported. Most live on welfare in a place called Mrs. Shaw's Motel, where an untrained but compassionate woman watches over them, calling the authorities when her rumors become uncontrollable. The legal services lawyer who brought the suit has no regrets. He says the largest and most heinous crime about the institution was that we had made people invisible. And a commentator on the experience concluded the failures of deinstitutionalization are in large part a reflection of inadequate community services, not of the fact that former patients were too sick to live outside the hospitals. There are a few changes in the wind. This past year, Governor Cuomo came up with a plan for New York's mentally ill, under which money saved in closing mental health institutions would be specifically allocated to community mental health service. That does not happen automatically, I can tell you. In 1955, there were 18 hospitals in New York for 93,000 patients. In 1993, there were 22 hospitals for 10,000 patients. After 40 years, there were 82,500 fewer hospital beds in the nation, but only 12,500 more community beds. So Governor Cuomo has tried to close down institutions, not beds, and he and the legislature eventually agreed on how to siphon $180 million saved from closing hospitals back into community service. He may have a tiger by the tail, but at least he's trying to do something about it. And there have been some spectacular success stories with other kinds of deinstitutionalized populations. In 1973, our same mental health law project successfully sued New York State to deinstitutionalize the notorious Willowbrook, the principal state facility for the mentally retarded, which was then housing 23,000 retarded persons in sordid conditions. By dint there of a pugnacious judge who not only ruled for the plaintiffs but stayed with the case for 25 years, and a resilient network of parents who lobbied incessantly for better community service and monitored them carefully, today only 4,300 of the former inmates remain institutionalized, and 11,500 are in generally adequate and satisfactory group homes. 9 institutions have been shut down. All are expected to be gone by the year 2000. Now, Dixon and its cohort litigation, I think, teach these lessons. Surfacing and identifying as a legal right an inequity in the treatment of a group, long suppressed, does not, in our complex society, carry with it any assurance that society will do better. David Rothman, the social historian, has aptly said that the reforms of one generation become the scandals of the next. And it's something for public interest lawyers to think about as they contemplate redistributive lawsuits. Yet on balance, I would not apply Rothman's aphorism to either Mills or Dixon. My experience does, however, suggest caution in one's aspirations, care in an attempt to predict at least the immediate consequences of a legal victory, and commitment to seeing the aftermath of such a lawsuit through to some tangible gain. Too many lawsuits cannibalize dozens of short-term lawyers until there are no survivors in the litigation who even remember how it all got started. The glory of a legal victory, even in the Supreme Court, fades fast. Some successes can be claimed on the basis of a court's legal ruling alone, but where a public interest lawyer enters the arena of public policy and resource allocation, she needs the energy and perseverance of a long-distance runner, not a sprinter, and the humility to be satisfied with incremental gains. The balance in determining when to bring a lawsuit with major implications for allocation of public monies is a very delicate matter. If a vulnerable population is suffering a loss in fact as well as in law, that alone may be enough, regardless of the dislocations that will follow. But should the lawyer not have to make a reasonable, if rough, judgment that the same population will not be worse off as an immediate result of a legal victory? And must she not be willing to pursue the proper remedy in many forums for months and years to come to make it a net gain for the hapless clients? If she hits and runs, as many part-timers in the public interest area do, can she rest easily with the simple notch in her legal belt? I leave it to you to ponder this enigma as you make your career and litigation choices. Now, the second area I'm going to talk about much more briefly is the government lawyer. Most lawyers who do not represent private clients work for the government, federal, state, or local. The government is, after all, supposed to be the ultimate embodiment of the public interest. A government lawyer works on behalf of the public as an elected or appointed official, in which role she gets to define officially what the public interest is. Every time an administration changes, at least in Washington, there's keen competition among lawyers for top government policy spots. I've worked as a lawyer for the government in several capacities, principally as a staff lawyer in the Justice Department and later on as an assistant attorney general there. I learned in those stints the constraints of government lawyering as well as its rewards. There are two decisions a government lawyer confronts during his career in the public service. What is the most enlightened decision for the public interest? And what if I disagree with the decision my superior has made about what is in the best public interest? At first glance, the first decision sounds energizing. But the criteria by which a public servant judges what is in the interest of the people is not always clear. She may look for the public interest as objectively defined by the popular vote, illustrated by opinion polls, or in the persona of an elected official who is her boss. What the lawyer herself subjectively thinks about the public interest doesn't usually matter too much, at least until one reaches the pinnacles of power. There are also long and short-term public interests in government lawyering. A particular position may seem to bring about the most appealing result in the immediate case, but in the long run present real risks as applied to likely future policies. The government is a repeat litigator in court. It cannot, or at least it should not, present one position today and another tomorrow. The government in concept represents all the people. If the interests of one group are pitted against another, on what basis does the government lawyer decide which interest should prevail? The one with the most constituents, the one whose benefits exceed the cost to others, or the one which occupies the higher moral ground? There are also institutional policies and precedents to take into account. No administration starts life anew. Cost-benefit analyses may militate toward letting some needs go in favor of others that will produce greater payoff for the resources expended. And politics are ever present in government policymaking. What will the political spillover be in adopting one policy over another? Is it fair to consider whether the right decision could result in weakening an administration to the extent it might be replaced by another that would make far fewer decisions in the public interest? Now, that's old stuff to political science buffs, but it's still surprising how many political appointees enter government service brightly self-confident, only to find early on that their options are severely constrained by departmental or agency tradition or precedent, political considerations, or even keeping the loyalty of their permanent civil service troops who can make or break a political appointee very quickly. Quite a few conclude it's easier to stick with the status quo than take the heat that envelops change makers. Experience shows, too, that if they do initiate reforms of any consequence, they could be gone before their time as their enemy quota expands until it's large and powerful enough to get them. There have been 7 deputy attorney generals in the last 10 years. The Federal Housing Administration has had 13 commissioners in the past 14 years, and 3 different assistant secretaries for post-secondary education served in one 18-month period in 1991-92. On the issue of deciding what's in the public interest, I cite a dilemma that I faced early on in my job as a Department of Justice congressional liaison. During his presidential campaign, which came on the heels of Watergate and the firing of Archie Cox in the Saturday Night Massacre, the special prosecutor, Archie Cox, the special prosecutor in the Saturday Night Massacre, President Carter had proclaimed support for an independent counsel law, even though the criminal division of the Justice Department had been traditionally opposed to it, and even though some Carter appointees in the department privately said it was institutionally a dangerous idea. The Attorney General, of course, was committed to the President's call on the issue, whatever his own personal opinion. But the Senate Judiciary Committee, not only its members, but its powerful senior staff, was very much divided on the issue, and the bill was destined to rise or fall there. Early in the hearings, one of the old-time staffers took me aside in the corridor and said plainly, "We know you have to follow the White House position in public. We also know the Department of Justice is conflicted on this. If you give us the word, we'll kill the independent counsel bill in committee." A nod would have pleased the older institutional interests at the department, probably not brought tears to the eyes of most appointees there. My role would probably have been indiscernible at the White House. Even then, a novitiate of government, I was not so naive as not to understand that. Out of a combination of my own personal beliefs, some ethical constraints, I obviously declined the offer. The bill became law, and the history of the 80s proved that to be the right choice. But earlier that year, a Department of Justice veteran of an even lower rank than I was accidentally left on the hearing room bench a very critical intra-departmental analysis of a motor voter bill supported by the White House, and the bill died in committee within 2 weeks. So there are opportunities aplenty for government lawyers to undermine their superiors' views of the public interest in favor of their own, temptations that are not always resisted. And finally, there comes a time in the career of some government lawyers when they confront the ultimate choice, a conscience that does not permit them to go along with the proposed position of the administration or the department. The conflict must, of course, be a very serious one, or the individual shouldn't have gone into government to begin with. The most famous resignations in recent times occurred during the Saturday Night Massacre in October '74, when President Nixon ordered the firing of Archie Cox to stop his judicial challenge to the president's claim of privilege on the Watergate White House tapes. Attorney General Elliot Richardson resigned rather than carry out Cox's dismissal, and Deputy Attorney General William Ruckelshaus followed suit. According to one account, at the time of resignation, President Nixon urged Richardson to delay his departure because of a Middle East crisis, and when he would not, accused him of putting his, quote, personal commitments ahead of the public interest. Solicitor General Robert Bork then became acting Attorney General and implemented the President's order, a course which haunted him during his later unsuccessful bid for the Supreme Court. History has treated the resigners well, bestowing upon them the label of men of principle, but it doesn't always work out that way. Last year, several mid-level officials in the State Department quit their jobs to protest U.S. policy in Bosnia, asking that we intensify diplomatic efforts, end the arms embargo against the Bosnian Muslims, and bomb the Serbian artillery then shelling Sarajevo. They all had promising futures. One compiled daily reports on the Serbian atrocities in Bosnia and said, this is from a Washington Post account, "You close your eyes and get holograms of the carnage in your mind." According to the Post, he handed in his resignation, writing, "I'm personally and professionally heartsick by the unwillingness of the United States to make resolution of the conflict in the foreign Yugoslavia a top foreign policy priority." Another said, "What we were doing was not only wrong, it was something I couldn't participate in. We would write stuff we knew bears no relation to what was happening, and ultimately you wanted to cry." Secretary of State Warren Christopher very benignly called his resignation the act of a, quote, young officer. Hundreds of congratulatory calls and notes followed the men's resignations, and one eventually found a job with a congressional critic of the Bosnian policy. The others left government at considerable sacrifice to their careers and to their pocketbooks. Resignations on principle usually produce a week-long flurry of television interviews and then deadening silence and the need to find another job with a threatening line on the resume, resigned in protest. In the case of Bosnia, the administration policy 6 months later tracked much of what these young men were asking. Was their early retirement worth it? Could they have been as effective if they had waited to press their cause of action later? By its very nature, government service is likely to involve more policy trade-offs and judgment calls than even private advocacy. Career civil servants can advise, but often they don't decide, and yet it is they who must carry out policies, whether they like them or not. Political appointees must be realistic about the compromises necessary to run government, yet they too can be seduced by the siren call of team spirit. Whatever it takes to keep the administration in power is by definition worthy. Critical choices come with that turf, and a government lawyer should always have some line he or she will not cross, some pang of conscience he or she will not suppress if he or she is truly to serve the public interest. And my final piece will be about the judge. That's a third class of public interest lawyer, the judge. She's a public servant, to be sure, sworn to devote her efforts to upholding the laws and Constitution, eschewing all private interests. Yet she's altogether different from a government lawyer who serves a political elected administration and advocates the best interests of that administration. A judge must be as wary of the political branches as of private parties. Her job often involves settling disputes between the two political branches. Indeed, Jefferson and Madison believed that a judge's primary raison d'etre was to protect citizen rights from majoritarian tyranny, even popularly elected tyrants. Only a fortunate few get the opportunity to judge, and I'm very grateful to be one of them, despite the relative anonymity and inevitable constraints it places on speaking out, staying politically active, and gossiping at cocktail parties. But how exactly does a judge advance the public interest? What dilemmas are lurking in this most enviable of public interest jobs? Why do a fair number of able, public-spirited citizens turn it down or eventually leave it for other jobs? What are the rules of the judging game? Now, tomes have been written on the appropriate role of a judge in a democratic society. In recent years, I think, unfortunately, they have tended to focus almost exclusively on admonitions that judges should not invade the policy-making functions of the political branches, the executive and the legislature. Judges in that taxonomy are activist or restrained, the first is bad, the second good, according to whether they give a lot or too little deference to the interpretations of statutes and the Constitution made by executive agencies. Most commentators on the judicial role now debunk the straw man of legal formalism, the judge who mechanically applies a set of rules called the law to each situation, as well as the more extreme forms of legal realism in which all sorts of factors personal to the judges, including what they ate for breakfast, combine to produce one decision rather than another, sometimes called the chaos theory of decision-making. Reasonable commentators recognize the need for judges to follow ascertainable rules and to be insulated from economic or personal ties that might motivate them not to follow the rules. But they also recognize that where fixed rules do not resolve the matter, the judge should and does make decisions that try to maximize social welfare. In Boston University Dean Ronald Cass's words, the judge is constrained from most outcomes by governing authorities and takes those authorities seriously. But the judge's own internal compass, his sense of justice, of good results, of proper professional conduct, can exert a powerful influence on decisions. Many controversial decisions about desegregation, about rights of criminal defendants, about speech rights seem difficult to explain apart from this factor. I think in the main Dean Cass is right, but let me take his formula through the paces in a few areas of judging that I deal with to show you how at least one judge tries to define the public interest. The first would be agency cases. You've heard about the D.C. Circuit and how many regulatory agency cases we have. Up to 60% of our docket consists of appeals from these regulatory agencies, where candidly, the judge's greatest challenge lies in understanding the nature of the dispute between the parties, deeply embedded, as it usually is, in arcane scientific and technical terms and equations. Generally, we only decide agency appeals against the government if we can't understand the agency's reasoning at all, or we think it missed some vital inquiry, or occasionally, if the agency has definitely misinterpreted the statute. Of course, there's always a judgment factor in deciding how muddy the agency's reasoning has to be before we refuse to go along with it, especially if the result looks defensible. But rarely in the garden variety of administrative law cases do we come even close to factoring our own public policy preferences or doubts into our decisions. Now, Sierra Club versus Coastal was the longest decision I ever wrote. It was something like 150 pages, and it may go down in judicial archives largely for that distinction. But it also represented months spent in mastering the data on which Clean Air Act new source performance standards for fossil fuel utility plants were based. The end result was to affirm the agency, and although the case had enormous consequences for the utility and coal industries, it had little precedential value because of its fact-based natures. Many commentators said we let the agency get off too easily. The real reason behind the EPA's final rule was an abject submission to pressure exerted from Congress to save the West Virginia coal industry. As a judge, however, I was not supposed to take account of such criticisms, though I certainly knew about them by dint of all the involved parties and commentators mailing us all gratis copies of everything they wrote on the subject. The court's job under the Administrative Procedure Act, though, was simply to ensure the administrative process had not been capricious or unfair, and the agency had made a defensible choice. Now, there are many, many cases where I don't like the results that I approve. And if I were a legislator or even an administrator, I would definitely rule the other way. Yet principle, precedent, and even practicality, since my colleagues or those higher up than me would promptly reverse if I deviated far from the norm, stay my hand. Now, there is one aspect of administrative law, however, that has produced great controversy in our circuit, and that's the threshold doctrines of standing and ripeness, the gatekeepers of accessibility into the courts at all. These are entirely judicially made doctrines, and they determine whether courts ever get to the merits of a controversy at all. Each year, we dismiss about 15% of all of our appeals for failure to make it over these hurdles. The post-war Supreme Court, beginning back in the 70s, laid down a triple-pronged test for deciding who could bring an action in federal court. The plaintiff had to show that he suffered actual or imminent injury, that the injury was caused by the defendant's action, and the court could set it right. Sounds simple. But in complex government regulatory programs, particularly those that use governmental grants or economic incentives to motivate private third parties to act in a certain way, a showing that the third party is directly responsible for the plaintiff's injury is not so easy to make. I personally believe that the standing necessary to challenge a government program should be satisfied if the governmental action was a major contributory factor to the private party's action that caused the plaintiff harm. But a majority of my court presently doesn't agree, and it has imposed ever stricter requirements for showing direct causation, even when there are already legislative findings of a cause and effect relationship between the governmental program and the plaintiff's grievances. Many of us see an important public interest served in getting to the merits of real and serious controversies involving major governmental programs, and we find it more judicial activism than judicial restraint to second-guess the legislature when it specifically has made findings on the nexus required for standing. We believe that Congress has closer ties with the real world and better means of getting accurate information about how things work out there than we judges do. Let me speak very briefly, finally, on constitutional cases. When a judge is faced with construing the Constitution as opposed to a statute, the prism through which she views the public interest changes perceptibly. Our founding fathers perceived of the federal judiciary as the major bulwark for the individual against the will of the majority. One constitutional scholar has aptly observed that in almost every case in which they have declared a constitutional right, the courts have acted contrary to the discernible wishes of a majority of the people. Thus, judges can hardly defer to the political branches as to what is in the public interest in constitutional cases. The public interest must be viewed as the longer-term interest of the nation in honoring its constitutional pact. Where the constitutional text itself or prior Supreme Court constructions are not determinative, searches for resolutions that enhance the basic values enshrined in the Constitution must be launched. And I don't need to tell you that judges can and do differ on what those values embodied in the Constitution are and how they balance out against each other. The most vexing constitutional issues in my time on the court have arisen in the areas of race, gender, and sexual orientation discrimination. The problem of what, if any, and when racial or gender factors should be favored in government benefits programs has proven a continual source of controversy in our courts. Finally, a word on dissenting, and then I'm through. A judge's job is to resolve cases and to declare what the law is. But in appellate courts, as I've pointed out, the judges may not always agree. In many other countries, there's only one opinion rendered by a court. Whether all judges agree with it or not, the dissenters by rule are silent. The rationalization for this mode is that it's unsettling to citizens and to the development of a stable body of law to have judges publicly disagreeing with each other. Our practice, of course, is different. From the beginning, we've had a tradition of eloquent dissent, what Chief Justice Hauge called, quote, an appeal to the brooding spirit of the law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. A judge must still, however, think carefully about whether it really is in the public interest to take issue with majority opinion, display its weaknesses, and plead for a different result or rationale. Some judges, as a result, hardly ever dissent. Some make a career out of it. Most of us fall somewhere between. I agree that dissents are not likely to be undertaken. They strain collegial relations, and too freely indulged in, they undermine a judge's credibility with colleagues or even reviewing courts. Yet 15 years on an appellate court have convinced me unanimity is not always in the public interest. Doctrine evolves as a continuing dialogue among judges and among courts, and a dissent of substance has a healthy tendency to keep the majority responsible by forcing it to confront the most difficult implications of its holding. Many times the majority opinion is itself improved or refined in the process. Moreover, a dissent sends a message to other courts confronting the same issue, as well as occasionally to the Supreme Court, that there are two sides to the issue that must be weighed. They have currency in Congress, where in their aftermath legislative adjustments are often sought to nullify the court rulings. I don't subscribe to the notion that it's intrinsically better to be a joiner, even when one thinks the ruling is wrong, and no concessions are given by the majority to cure the harm asserted by the dissenter. It is, I will say, a much harder question when the majority is willing to give something up for your concurrence that will make the law less wrong or limit its harmful impact. Similarly, it's difficult to justify going along in order to arrive at an admirable consensus when a judge is still convinced her own painstakingly arrived at view is the right one. These days, our law changes dramatically and rapidly in many areas, and well-considered dissents can help pave the way for tomorrow's majorities. Judges are not infallible, in case you didn't know that, and it's not in the public interest to advance a myth that judges gratuitously dissent out of arrogance or pettiness. The public should see us for what we are, or should be, hardworking, caring, thoughtful, intelligent weighers of evidence and arguments, dedicated not just to the rule of law, but also to the rule of a law aiming at justice. We need to stay within our limits, but we also have much discretion, and the public needs to see how we use it or abuse it. If there's basic disagreement within a court about the direction the law is taking, the public needs to know that too. That is what I think judging in the public interest is about. Concluding, let me quote a provocative warning from Learned Hand, this is in the Gunther biography as well, about the need or the wisdom of consciously devoting one's career to serving others. And this is a direct quote by Hand. If it be selfishness to work on the job one likes because one likes it, and for no other end, let us accept the odium. I had rather live forever in a company of Don Quixotes than among a set of wraiths professing to be solely moved to the betterment of one another. Let us then, if one insists on candor, do our jobs for ourselves. We are in no danger of disserving the state. Now, not every great judge has agreed with Hand on that. I would say Justices Brennan, Marshall, maybe even Holmes probably didn't. Certainly my old boss on the Second Circuit and Learned Hand's good friend, Jerry Frank, did not. He was an irrepressible reformer. Many of us feel the shadow of justice, however ephemeral and gossamer its shape, hovering at our side. Order and discipline, in Hand's words, quote, a complicated series of formulae which we impose upon the flux does not sufficiently define what we are about for some of us. For many of us, and for you, I hope too, there must be a resonance of our work in the world around us. Theory and justice must meet sometime, somewhere. Good law must improve the lot of mankind, not denigrate it. A lawyer or a judge is not a pure mathematician or physicist searching only for eternal principles that already exist somewhere out there. She is a channeler of that flux Hand talked about. But, and this is finally the simple end of my message to you, she must be a careful and responsible channeler. Good intentions will not suffice. While the law of unintended consequences visits all of our efforts, those who work in the public service or for the public interest have special obligations to try to anticipate some of those consequences and stay the course to mitigate or divert them. To take Hand's advice literally would make the ideal lawyer a kind of Alec Guinness supervising the building of the bridge over the River Kwai with attention only to craftsmanship, oblivious of the role that bridge will serve in the greater war. We need well-built bridges, but in the right places for the right reasons. It's very hard work, and I wish you well at it. Thank you.
Judge Wald, thank you for a remarkable study of the law in public service. Let me close then with thanks to Christy Clifford, Barbara Gauditz, Joanna Emmerling of the law school staff for making this all seem so effortless, the several days of the Coffin lecture visit. Judge Wald, you have inspired us. You have sobered us. You have challenged us. You've made the third Coffin lecture one that will be long remembered. Thank you all for attending. We look forward to next year, and it is my great pleasure to announce that our fourth Coffin lecturer will be the Solicitor General of the United States, the Honorable Drew Days. We will see you next fall. Good evening.
TV4, Extraordinary Television, the Community Television Network.